And as the Nupur Sharma case splits the judiciary wide open, joining me now is former Attorney General, one of the country's leading advocates, senior advocate Mukul Rohtgi. Appreciate your joining us, Mr. Rohatgi. As you're seeing, the observations made in the Nupur Sharma case seem to have split open the judiciary. There are those today who are writing in saying that the judges crossed a Laxman Rekha with their comments that they made in the case. Do you agree with that? Do you believe a Laxman Rekha was crossed when the judges criticized Nupur Sharma?
Rajdeep, I don't think they have crossed any Rekha, much less a Laxman Rekha. I mean, I am amazed at how people trained in the law are commenting on oral observations which do not form a part of the written order. Judges are not, sphinxes. They are human beings. They react to situations. There is nothing like black and white. There are a lot of grays in it. So a judge reacts. Sometimes the judge may be angry. Some judge may be upset. A judge may feel relieved or whatever. So a judge also reacts. But it is elementary, if I may use that phrase, that oral observations are never taken into account. You only go by the written order, because observations can be misconstrued, misunderstood. And please understand, Rajdeep, if after 2 years this short order is cited in some other case, will there be a debate of what A judge said, what B judge said, what C judge said when the hearing was going on? So there is, there's a hullabaloo for nothing. There's much ado about nothing.
You're saying much ado about nothing, but this is a politically sensitive case, which is why any observations in a case like this seem to get magnified. And that is the worry. When, for example, the judges suggested that she was single-handedly responsible for what was happening in the country, or indeed responsible for what happened in Udaipur, given the fact that this is such a political hot potato, should judges be wading into it at all? The signatories to the letter today suggest this is not in sync with judicial ethos, cannot be sanctified on the plank of propriety and fairness.
Rajdeep, I do not agree with you at all. A judge is a human being. He sits there in that chair from 10 to 4, hearing a weird type of cases. When a lawyer argues, a judge has to react. Cannot just sit like a blank sphinx who will not react. Not a machine. So he has to react. A judge reacts to a fact situation. But as I told you, there is a record of these observations. There is no system of recording an observation. This is what is picked up by the press and highlighted. Otherwise, a court only goes by the record. Can you imagine the problems this kind of argument will create? So an order is passed by the High Court. Let us say the High Court judges were angry in passing an order. We file an appeal in the Supreme Court. When I argue an appeal in the Supreme Court, I argue the basis of the written order, whether it's right or wrong or according to law or not. I don't tell the Supreme Court that the judges were upset about it, the judges pulled me up, the judges did that, or the judges were favoring one side and the prejudice against me on certain facts. You don't say all that. You argue a case of the merits of the written order.
Okay, you're saying you have to focus on the written order, not on the observations. Effectively, therefore, Mr. Rohatgi, you seem to be in consonance with what Justice Pardiwala said. He said, personal attacks on judges for their judgments will lead to a dangerous scenario where the judges have to think what the media thinks instead of what the law really thinks. You seem to agree with that.
I think the judge is absolutely right. A judge can't defend himself. You say he said this, he said that, he was prejudiced, this, that or the other. How does the judge react? Therefore, if I may sound a word of caution, the newspapers and the electronic media should not highlight comments which go across in a case between the bench and the bar. Sometimes there is laughter, sometimes there is banter in the court. That is not meant to be, reported in this fashion. You have to have sometimes a light atmosphere in court. Sometimes judges also crack jokes. They crack jokes on the petitioner or the respondent, saying, sometimes the judges have told me, your client has deep pockets, or your client can do this, can do that. Those are matters which go on in the court. but you go by a written order.
You know, but
our judges are very experienced.
sure,
They
but
don't go by, you see, these observations.
But you're saying go by written order. Now, there's also been a controversy over written order of the Supreme Court involving Teesta Setalvad, for example. Now, this was a case, I know, where you argued, but the fact is there, some are arguing that the judges have effectively goaded the executive to arrest Teesta Setalvad, which happened 24 hours later. So, again,
listen now,
there are concerns.
You are changing track. So let's now forget this Nupur Sharma case. Now let us go on the Teesta case. Well, I had argued, and I repeat, that Teesta was using Zakia as a front and as a name lender. She joined the proceedings in the High Court. She was not a victim. She was not aggrieved. She, according to me and my arguments in court, she was using it as a platform. And therefore, there were instances where affidavits were forged, either by her or by an organization or somebody under her control. All that is a matter of record. People said that we don't know what we have signed. So that's the kind of stuff we have argued. The court found favor. It's a 400-page judgment, mind you. It's not an off-the-cuff judgment of half a page or 1 page, where the court found substance in what we were saying and therefore recorded that here was a person who challenged everybody from the top to the bottom of the political organization, of the police, of the fire department, of this, of that. I mean, that's how it happened. The idea was to somehow nail the political heads in the state at that time to say that they were instigating the mobs. I mean, the judge heard.
So you're making a distinction between oral observations and a written order. Am I correct?
Yeah, so a written order. Now, Rajdeep, if the written order, according to some people, is excessive or has gone overboard, as you said, in goading, etc., then there is a legal remedy. You can file a review petition and say, look, these passages are uncalled for. They are not relevant. They are not germane. They are prejudicial. Therefore, they may be removed. Every day, passages are expunged by the Supreme Court in its own judgment and judgments of the High Court. But can you apply the same principle to, oral observations? Can I tell a court that 1 year ago you made some observation, now expunge them? I mean, this whole thing is absolutely, there's nothing in it, just smoke without fire.
Let me therefore ask you in conclusion, because I've heard the likes of Kapil Sibal, like you, a senior advocate, suggesting that he hangs his head in shame in the way the judiciary is moving. There are others like Justice Madan Lokur who have also suggested that it would be extremely troubling, as he said, heaven help us, if the top court intended that Teesta Setalvad should be arrested. In a sense, does the judiciary also need to press the pause button, introspect or not?
Well, I think it is an unfair comment on this judgment, which is a detailed expression by a court of 400 pages. If some passages are wrong, if there is a remedy available, and that remedy can be by moving the court that you should not have intended that these people would be arrested. Okay. And if the court finds favor, it can be withdrawn. What is the problem? Every day the Supreme Court withdraws its judgment, modifies its judgment, clarifies its judgment. Every day it happens. So what's the great hullabaloo about it? Why doesn't people who are aggrieved with the judgment move the court?
So you don't think there is something seriously wrong at the moment at the highest judiciary in the manner that they're getting tangled in these political cases? You instead believe it's the media which must show restraint even more than the judiciary. Am I correct?
I have no doubt that the judiciary is trying to grapple with all issues, including political. The political issues have to be addressed. The Supreme Court cannot shrug its shoulders and say, we won't address them. They are under a huge burden of cases. Every judge is sitting with a great burden every morning to evening and then writing judgments in the night. It is not fair to criticize them. All I would say is that the media should not play up every comment, everything which happens in the course of an argument in court unquote, and say that this is the view of the court. The view of the court is the written order and not any oral observation. Let's be clear about it.
Okay, fair enough. And you've been very clear yourself about that, Mr. Rohatgi. I therefore appreciate your joining us and giving us your perspective. Thank you very much.
Thank you.